We're now in a period where often states' rights are being deployed in ways that are more harmful to individual well-being than beneficial. There have been many moments in American history where there's been conflict over the balance of power between the federal government and the states. Oftentimes, this has been a contest over some question to do with the role of race in American politics and the economy. For example, before the Civil War, there was conflict between the federal government and the several states over runaway slaves in the North. And the national government, at the behest of southern states, passed two what were called fugitive slave acts as ways of limiting state authority and forcing the rendition of runaway slaves. In contrast, after the Civil War, there was a short period in which the federal government aggressively exercised power, including through military occupation across the South, as a way of reorganizing economic relations in southern states in ways that reallocated power and effectual citizenship to Black Americans. The important lesson from that period is that the effort on the part of the federal government to restructure many social and economic levels in the states failed because southern states were able to push back in Congress and ultimately unravel Congress's efforts at exercising military power and legal power to the benefit of Black Americans. These days, one sees lawsuits commonly brought by Republican-dominated states, such as Texas or West Virginia, that are brought to challenge aspects of federal policymaking that these states don't favor. Just over the holiday period, a Republican state-led coalition of litigants succeeded in blocking the Biden administration from altering what's called the Title 42 program, which is an immigration program that was limiting the flow of migrants across the border. A few months before that, we saw litigation successfully challenging the Environmental Protection Agency's authority with respect to climate change-related rules. Obviously, the recent opinion in Dobbs concerning abortion is going to open up a whole new front of conflict. An example of the way in which the Roberts Court has been open to state challenges to federal law in ways that weaken our democracy comes from the voting context. So in a series of cases involving both the constitutionality and the scope of different elements of the Voting Rights Act, the Roberts Court has narrowed or done away with key elements of the federal law regime that protects individuals' right to vote. The immediate effect of several of these rulings has been to catalyze increasing numbers of state laws that impose restrictions upon access to the ballot, which, at least allegedly, have a burden that falls disproportionately upon African American and minority voters. American federalism is not something that has had the same ideological orientation over American history. Its meaning and its effects have changed over time. It's important to remember that we have a complex system of government where the effects of particular design choices, like federalism, are subtle and are evolving over time, depending upon whether one side or another is able to capitalize on and mobilize efforts with respect to that aspect of our constitutional order.